Hi, and welcome to our webinar, Produced Water, Other Brines, and the Substances in Them. Who has the right? I'm Ryan from Pizzuli, Program Manager of the Institute for Energy Law, which is an institute of the Center for American and International Law. This webinar is hosted by IEL's Academic Outreach Committee and is the second of two sessions we have planned on traditional oil and gas academic topics. The first one is available on demand. I would like to thank IEL's online learning sponsor, Baker Botts. I would now like to welcome our speaker, Professor Keith Hall. Professor Hall holds the Nesser Family Chair in Energy Law at Louisiana State University, where he serves as director of the Mineral Law Institute and as director of the John P. Labrador, is that correct?
Laborde.
Laborde Energy Law Center. He teaches mineral rights, international petroleum transactions, civil law property, and energy law and regulation. Professor Hall is the co-author of 3 books on oil and gas law and is the co-author of a 4th. He is also the editor-in-chief of IEL's Oil and Gas e-report. Keith, over to you, and thank you.
All right. Well, thank you, Ryan, and I appreciate the invitation to present today. And let me share the PowerPoint slide. The other substances that we're going to focus on is mainly lithium. So I want to mention that up front. And we're talking about produced water, other brines, because we're largely going to be interested in production of lithium that's found in that water. And so that's the explanation of the title. And this is a growing issue of growing importance. We've been producing lithium since the late 1890s, and it's used for a variety of purposes. But the largest use currently, and also the fastest growing, so it's even becoming a bigger market portion of what do we use lithium for, is in rechargeable batteries. This is a relatively new use, goes back to the 1970s. Perhaps I date myself by calling something that goes back to the 1970s relatively recent. But if you think about your cell phone or your laptop computer, or electric cars, and potentially energy storage batteries for the electric grid, anything that you'd be recharging batteries, typically that has a lot of lithium in it. It's of great economic importance, and also now there are national security concerns because we mine or produce a relatively small fraction of the lithium we use here in the United States. And also because one of our potential rivals or adversaries, China, really dominates the lithium processing. Not so much the production, although they're a significant producer, China is, but where they really dominate is the processing of the raw lithium to get it into batteries. So as far as the outline of the presentation, I want to talk about the type of substances from which we get lithium. Does it produce water, or is it some mineral ore? How do we extract lithium when we produce it from briny water? Where are the potential production locations? Who has the right to produce lithium from brine? Who has that extraction right, which is what a lot of mineral law lawyers, particularly title lawyers, but really a variety of mineral law lawyers will be interested in? And then what are a few other legal issues to be thinking about? And by the way, when we get to the last slide that I intend to use, which will look like a last slide of a slide deck, after that, I have some slides I did not intend to look at today, but they're purely for reference. So I may refer occasionally during the presentation to those slides at the end of the slide deck. So with that, so how do we produce lithium, or where do we produce it from? And you're not going to find pure lithium out there. It's so reactive that you're not going to just find anywhere chunks of lithium metal. It is a very light metal, the lightest of all the metals, which is one of the, I guess, important characteristics that makes it valuable. Not only does it have some of the electrical or conductivity properties that make it useful, but it's also very light, which can be useful in a battery that you want to be portable and move around. So you're not going to find lithium in its pure state, and you'll find it Where do we find it currently? There are places where we mine an ore, so what you'd think of as traditional mining to get ores that contain lithium. Also, a major source of lithium today is from briny water, salty water. And this is not produced water that comes up with oil and gas activity. This is just brine that you would potentially pump that brine and recover the lithium from it. As far as potential sources, there are certain clays that contain amounts of lithium that can be economically recovered, the technologists believe. And also there's increasing interest in produced water, that actually does come up with oil and gas production, but that might contain in it some lithium. So how is lithium produced? And here I'm going to focus on the lithium that you find in water, not how you'd process an ore if you're doing traditional mining, but how do you produce it when it's found in water? And first, you'd have to get the water to the surface. So this could be, if you're talking about produced water, well, it just come up with the oil or gas, and you'd have to separate in your oil water separator the water. If it's subterranean brine that's not produced water, you'd have to pump that to the surface, and then you have to get the lithium out of the water. How do you do that? Right now, the most common method, which is the most common historic method, is evaporation ponds. This doesn't work very well in some places, but if you've got production of lithium in a very arid area without much rainfall and low humidity, like the desert, and where land is also cheap, you can have just huge evaporation ponds. Talk about maybe a mile long and maybe multiple evaporation ponds. And this is actually the dominant way we get it now. But going forward, we're thinking about and talking about producing brine from water that might be found in locations that are not so arid, where evaporation ponds would not be as efficient. Even in the desert, this is not a very fast process to recover lithium by evaporation from the water. But in some areas, evaporation ponds just would not be practical as far as the how long it would take if you have too much humidity or too much rain. And also, if you talk about multiple mile-long evaporation ponds, that might be very expensive from the land use side also. And so we're talking about direct extraction of lithium through chemical means from those locations is what we'd be talking about. And so here is just a photograph of some of the really huge and multiple evaporation ponds in Chile. Much of the brine comes from the so-called lithium triangle today in South America. There are other places. We have a little bit of brine production in from the desert out west in the U.S. There's some mining for lithium in Australia and China, but a big portion of the lithium comes from South America. Rather than using those evaporation ponds, as I've already mentioned, you could produce it through some chemical means, often called direct lithium extraction. And basically what you would do is pass the briny water that contains lithium through some vessel that contains a lot of, maybe they're small spheres that are made of a substance where the lithium tends to come out of the water and absorb onto the surface of that spherical particle. And then once those spheres that attract the lithium are largely saturated, you can stop the flow through that container that has these spheres, these adsorbent spheres, and then do something like raise the temperature or do something to get the lithium to come off the surface. And in the meantime, while you're doing that, you probably have a second vessel that contains these spheres. And when you're recovering the lithium from the surface of those spheres in one vessel, those adsorbent spheres, you'll start passing your briny liquid over the other vessel. So that's what we're talking about. as far as how you do it. And if this is the way you do it, you might have in this photo, or not photograph, this diagram, that vertical black bar to the right is representing the production well. So you pump the brine up, send it through the direct lithium extraction process, and have your lithium. Then the water that's now lean, or in a lower concentration of lithium, you'd probably pump that back into the same formation. So it looked kind of like what some folks in the oil and gas industry would think of as a water flood project, or for secondary recovery. And so this is what it looked like, and this may mean you're going to need a large land area to do this. Where is there potential production in the U.S.? And this is one of the places where I'll point out that at the end of the slide deck, there are some other slides that show potential places where we're actually thinking about mining, or where companies are thinking about mining lithium ore, or recovering lithium from clay. But the main sources I think this audience is probably going to be interested in or one of the main locations is the so-called Smackover Formation, and it's got its sweet spot as far as lithium concentration in southern Arkansas, though the formation does extend into Texas, also into northern Louisiana, and this is where, if we're talking about pumping brine, this is a location that's the really promising location. And there's actually a lot of lease activity. There are 3 really large leaseholders. There are some smaller leaseholders, but Exxon has a very big lease position there. Standard Lithium, that's now partnered with one of the Norwegian oil companies, Equinor, has a big lease position. And Albemarle, which is today one of the world's largest producers of lithium, that does a lot of the operations in South America, also has operations in the U.S. desert. Albemarle has a big lease position in Arkansas. Albemarle has historically operated in Arkansas to recover bromine from brine, and so they already have operations for bromine in southern Arkansas. As far as produced water, there's interest in several places. There's been testing and analysis of produced water in Texas as far as how much lithium is there. There is a relatively recent, a few months ago, National Energy Technologies laboratory study that showed that lithium is present in some of the produced water in the Marcellus Formation. So another place where you have oil and gas activity, and where some of the members of IEL are from that part of the country. And that NETL study suggested that probably enough lithium that you could consider making a go of it commercially there. So that's a little bit of background, but the main thing that the mineral law lawyers are going to be concerned about, is who has the right to produce the lithium, who has the right to extract it, from whom do you go to get a lease if you're going to lease, the rights to extract lithium. And here I think it's going to be a little more complicated than with oil and gas, in part because the law is not real well settled yet, and in part you could also be dealing with a lot of severances or existing leases where it may not be clear if they cover lithium. Now, an initial question you could ask is, are there any mineral severances that particularly talk about lithium, or that talk about groundwater? And if the answer is no, then if both the groundwater rights belong to the landowner, assuming you're in a part of the country where that's the case, and there have been no severances of minerals or groundwater rights, well, then you're going to go to the landowner. But if there have been severances of either mineral rights or water rights, then you're going to need to go to some additional questions. And it'll probably vary the analysis somewhat on whether you're talking about mining, which I'm not going to talk much about today, or if you're talking about produced water, that comes up with the oil and gas, or is it some other brine that you're intentionally just pumping the brine itself and then trying to recover the lithium? I think you'll basically come down to a few questions or a few things that are going to have to be resolved. And one question that is going to be asked and that will be important for you to get a handle on is who owns the water that's at issue. And because some people are going to argue, and maybe in some states it'll be the case, that whoever has the right to that water will also have the right to whatever's in it. But that's not necessarily the case that who has the ownership of the water will also have the right to any substances in the water. So another question that is going to be important to ask is if there is anything that qualifies as a mineral in the water, and I'm assuming that there are no leases or mineral severances that specifically mention lithium, but if there's been a severance of minerals, perhaps, would someone else, perhaps who has the right to minerals, have the right to extract minerals from the water? And if so, perhaps you'd have the right, even if you don't have the right to the water, but you have the right to minerals, you may have the right under the implied easement of reasonable use, or you have reasonable use of the land where you have mineral rights of some sort. You may have the right to use that water to extract your lithium, just in the same way that you'd have a right under Texas law and some other states' law, perhaps, to use some amount of surface water or groundwater for a secondary recovery, or just like you have in your applied easement of surface use, you have a right to use the surface to extract minerals. So you might, if you are the mineral owner, have a right to extract anything that qualifies as a mineral from the water, even if someone else, like the landowner or a water estate owner, owns the water. And so you'll want to think about, does someone who, other than the person who owns the water, have the right to extract minerals from it? And then, is lithium a mineral? And that's going to be a question that's going to be sometimes challenging to answer or very interesting to answer, and this will probably be state specific. So who owns the groundwater? Well, in most the parts of the country where I think probably most of the audience comes from, it's going to be the landowner. And you may have, if you're the landowner, a right to pump an unlimited amount of, extract an unlimited amount of groundwater under property law rules. And that might be the case in Louisiana, Texas, for example. Or you may have the right to extract groundwater if you're the landowner, but be subject to a reasonable amount of pumping. But one way or another, the landowner in most of the area of the country from which I think the audience comes is going to have, the landowner's going to have that right generally. That's at least the starting point if there hasn't been any granting of water rights by the landowner. Now, there may be some parts of the audience that are in a so-called prior appropriation state, such as in New Mexico. This is thinking of one example from which there may be some audience members. There, in those prior appropriation states, which are mostly Western states, the land ownership doesn't come with water rights, and water rights are largely based on first use, whoever put it to first beneficial use. And so there it's going to be a little more complicated than just pointing to the landowner. So these are mostly Western and and a lot of times arid states that have the prior appropriation, where water rights are not tied to land ownership. And as I stated, one example is New Mexico. There are certainly several others that have prior appropriation, but I point to New Mexico and include a citation to one of its Supreme Court cases. Just, I picked New Mexico because it's one of the prior appropriation states from which you have a lot of oil and gas activity, and therefore perhaps some folks who are involved in the IEL and are part of this audience. Most of the rest of the country, one way or another, the landowner is going to have water rights. Usually, the rule of capture will apply, that meaning that any water the landowner pumps and has a right to pump will belong to the landowner, even if it drains from beneath the neighbor's property. So sort of like with oil or gas, the rule of capture will apply. And in some of these states, the landowner, not only will the rule of capture apply, but the landowner can pump an unlimited amount of water, even if it harms the neighbor. In other states, the rule of capture will apply to whatever the landowner pumps, but the landowners will be subject to a limited, reasonable use amount. Just as examples of states that have no limit on the amount of water the landowner can pump are Texas and Louisiana. These are not the only states that have no limit, but there are two examples from which I anticipate there are probably members of the audience. Now, in these states, there could be regulatory limits, but as far as the property law limits, there's no limit. You could, not only does the rule of capture apply, but you can pump as much as you want, even if that lowers the water table, even if this harms the neighbor by maybe dropping the water level to a deeper level than some existing wells on the neighbor's property. This system where there's no limit to the amount pumped is sometimes called the English rule, sometimes called absolute dominion rule, if you start looking at some of the old cases. Also, if you look at the old cases, by the way, if you see some of the courts will try to distinguish between what they call percolating water versus water in a subsurface stream. And the percolating water is what we would normally think of as groundwater. It's not in some subsurface stream where there's some really easily identifiable flow path. And so most of the groundwater we talk about is percolating water if you start looking at some of the old groundwater cases. So because Texas would be an example where not only do we have probably a large portion of the audience from Texas, but also it just has several relevant cases. I'll point out, here's a Texas Supreme Court authority that the surface owner owns the groundwater. So there's that authority. There's Texas Supreme Court authority that you can have a groundwater estate that is severed from the surface owner. So the prior slide, said that the general rule is that the water belongs to the landowner, the surface owner that is, but you can establish a groundwater estate. However, if you've got a mineral severance, that doesn't include the water. So you'd have to have a particular severance of the water rights, of the water estate. Water's generally not going to go with the mineral estate. Now, the mineral estate owner under the implied easement of surface use may have a right to use a certain amount of water to further the oil and gas operations, for example, for frack water or water for secondary recovery, but the water estate itself, the groundwater for using for other purposes, that's not going to go with a mineral severance. This is true even if the water is salty, and the Robinson case, Texas Supreme Court case is authority for that. Here, it's important to note the parties were not fighting about the salt or anything dissolved in the water. And the Texas Supreme Court said if that had been the case of what they're fighting over, the substances in the water, it'd be a different analysis. But here, and the mineral owner might have the right to extract the salt or the other substances. The Texas Supreme Court didn't have to resolve whether the mineral owner would have the right to extract the substances. It just recognized that would be a different case. Here, they were using the water, the parties were fighting over use of the water as water. The mineral estate owner wanted to use the water as water for a secondary recovery and tried to argue, or did argue, but unsuccessfully, that because the water was salty, it would not be part of the surface estate and would be part of the mineral estate. And the Texas Supreme Court said no. Even if it's salty, it still belongs to the surface estate. And therefore, if you're going to use this, you have to rely on your implied easement of surface use or go to the landowner and get water rights. And here's just a Texas Supreme Court authority that the rule of capture applies. So not only can you pump an unlimited amount, but the rule of capture applies to whatever the landowner or person with the groundwater estate pumps. As far as states with a reasonable use limitation, I've listed several here. This is also not an exhaustive rule. There are other states with the reasonable use limitation, but here are some that include states with oil and gas activity and or other mineral activity. These states apply what's sometimes called the American rule or the reasonable use doctrine or the riparian rule. And I have authorities for the fact that these all do follow the reasonable use limitation at the end of the slide deck. I also have slides at the end of the slide deck for the proposition that I previously stated that in Louisiana, the landowner is the person who usually has water rights, and that the rule of capture applies. So you can find the legal support for these statements at the end of the slide deck. But here are some of the states that would say the landowner owns the right to pump water from the land. The rule of capture is going to apply. So even if you drain some water from the neighbor, you can do that. But you're subject to reasonable use. This reasonable use doesn't mean that you're limited to pumping your proportionate share. But if you start harming the neighbor and making it where the neighbor's not going to be able to get any water, that may be an exceeding the reasonable use. So in most states, unless you're talking about some of the Western states where they have prior appropriation, the landowner is going to be the person who owns the water. You're going to be able to pump water, and the rule of capture is going to apply, though in at least some states you may be limited to a reasonable use standard. That also assumes that the reasonable use limitation will apply to salty water. A lot of these cases are dealing with fresh water, and I think there may be an overlay kind of in the background that the courts want everyone to be able to have a water well on their property for drinking water or for irrigation or their livestock. If you're talking about water that's not really suitable for freshwater use, I just query, would the reasonable use limitation apply? I'm not sure, but the best we have of actual authority to go on is to look at those groundwater cases, most of them dealing with fresh water, but where the reasonable use doctrine applies. But in any event, it's going to be the landowner. With respect to produced water, it's going to be, I think, more complicated. Historically, produced water has been a waste that no one wanted. The oil and gas producer was charged with the regulatory responsibility for getting rid of it. And it really didn't have much value. So no landowner was raising their hand to say, I want the produced water. But now there's some potential disputes. And one potential answer is, well, this is subsurface water. So just like other water, it would belong to the landowner. But there's also the potential argument that because this comes up with the oil and gas stream, and because it's typically and historically has been an oil and gas waste, and because there's this regulatory responsibility to do something with it, that it's just understood or it's just intended that even if the mineral oil and gas and mineral lease doesn't say so, that it's just intended or understood that the mineral lessee would have the right to and would own any produced water. So that's a possible alternative. One possibility, the produced water belongs to the landowner. The other possibility belongs to the oil and gas operator. Because this is a property right, property issue, it's going to depend on a state-by-state analysis. In some cases, you may have statutes that address this. In New Mexico, There's a produced water statute that's intended to, I guess, supersede the prior appropriation rule for purposes of produced water and to encourage oil and gas operators to recycle produced water, reuse it some valuable way. New Mexico is an arid state, and this is intended to make it clear that the oil and gas operator can own it, because the oil and gas operator typically be the only person that might have any incentive to reuse it, as opposed to just putting it down an injection disposal well. Now, this statute, only dates back to 2019. So one issue could be, if there's a dispute between someone else and the oil and gas operator about ownership of the produced water, would this statute apply retroactively to pre-2019 mineral leases? That could be a question. Also, if you're not talking about using the water as water, but taking something out of it, would the same analysis, would this legislation apply? The legislation does say that byproducts that come from the treatment of the produced water would belong to the oil and gas operator, or whomever the oil and gas operator assigns those rights to. But is lithium, if it's becoming a valuable product, not just is that really now a byproduct? If you're treating water to reuse as water and something comes out of that to make this water more pure, to me that sounds like a byproduct, definitely. Is it still a byproduct if it's actually pretty valuable and you're deliberately extracting lithium or some other substance from the water? I think people could argue one way or another about whether it's a byproduct. If it's not a byproduct, then the statute wouldn't address ownership of any valuable substances taken out of the ground of the water. Oklahoma also has a statute that goes back to 2020 saying that the oil and gas operator owns produced water, but it explicitly says that if you start talking about constituent elements that you extract from the produced water for commercial purposes, then you have to go look at their Brine Development Act, that would be the act you looked at, not this statute that declares that the oil and gas operator is the owner of the produced water. Texas has 2019 legislation that says that unless the oil and gas lease provides otherwise, the produced water belongs to the oil and gas operator. And again, it also, kind of like the New Mexico statute, says that byproducts of the treatment of the water can belong to the oil and gas operator as well. But the query is lithium or something else that has real value. If that's the target, it's not just some incidental thing you produce when you're purifying the water for your next use of the water as water. But if you're going after the lithium and it's valuable, is that still a byproduct? If so, then this statute would say that the oil and gas operator owns that byproduct. If it's not a byproduct, then I think the statute is silent with respect to valuable substances. Also query, would this apply to oil and gas leases granted before 2019, before the effective date of the statute? And by the way, all this legislation does contemplate that if the lease explicitly says that the produced water belongs to someone other than the operator, then you'd apply the lease. But this is assuming that the oil and gas lease doesn't address ownership of the produced water. There's a Texas case a lot of you will have heard of already that's gotten a lot of attention that concerned produced water. And here you had the oil and gas operator, COG, operating, and you had a company to which the landowner had granted the right to produced water, explicitly granted the right to produced water. And now there's the fight between this kind of water lessee, produced water lessee, and the oil and gas operator under the earlier granted oil and gas lease. And the Texas appellate court said that not relying on the statute that I mentioned before, but just relying on interpreting the oil and gas lease and the rights, that because the historic practice was that this was something taken care of, the produced water by the operator, that you dispose of it as oil and gas waste, it wasn't going to interpret this as just under the typical lease language. This was not some lease that talked about ownership of the produced water, but just said the typical oil and gas lease that doesn't mention who owns produced water. It'll be the operator. The court also looked at some of the statutory distinctions between groundwater as a defined term and oil and gas waste, and concluded that the courts analyzed it as if the produced water could not be both groundwater as contemplated by some of the older statutes and oil and gas waste, and said it's definitely oil and gas waste, and therefore it's not groundwater. And the court also looked at some of the older statutes for that purpose, but was really just interpreting ownership under the lease. There's been a petition filed for review by the Texas Supreme Court, but the last I checked, the Texas Supreme Court had not indicated whether they're going to really take up the case on the merits. But this obviously, because they're interpreting the typical oil and gas lease as giving the operator the ownership of produced water, this could apply to, to older leases, obviously. Louisiana has some fairly recent legislation that likewise, like some of the other statutes, says that unless the oil and gas lease provides otherwise, produced water belongs to the oil and gas operator. And this statute, though, also says that the substances in the produced water also belongs to the oil and gas operator. So unlike the Oklahoma statute that says that we're not declaring that the oil and gas operator automatically owns the substances in the produced water, and unlike the New Mexico and Texas statutes that refer to byproducts, but wonder, is lithium a byproduct when you remove it from the water? The Louisiana statute seems to clearly attempt to say the oil and gas operator is going to own the substances in the produced water as well as the produced water itself. Again, a query, would this legislation apply to older leases and mineral servitudes, or our version of a mineral severance that existed prior to the effective date of the statute? And then after you sort out who owns the water, as I indicated earlier, that may not be, and probably is, a lot of cases will not be the final question, because if, let's say, the landowner does own the water, but there's been a mineral severance. And let's suppose this mineral severance didn't explicitly list lithium, but had some specifically listed substances like oil, gas, and minerals, or maybe it just said we're granting mineral rights and severing mineral rights. If that's the case, is lithium a mineral for purposes of the lease or the mineral lease or that mineral severance? And this is going to be a state-specific thing, again, because like oil and gas and water rights, this is a matter of property law, so it's going to be state-specific. And unlike some things where, say, with respect to oil and gas, every state that I'm aware of applies the rule of capture. And there are some things that just work a certain way everywhere. The analysis is different in one state or another about what does the catch-all term minerals mean. Obviously, if you've got a mineral severance that specifically lists by name the substance you're talking about, or that's in conflict, obviously then that severance is going to apply to that. But what if the severance just says minerals? Or what if it says, substance A, substance B, and minerals? Is lithium, and mineral. And a lot of the states, most of the states will consider at least as one of the things they consider. Sometimes the only thing they consider is what's the general understanding of the term minerals, not some scientific definition, but what's the general understanding. Some states apply the justum generis doctrine that says if you've listed a few specific things, then the catch-all minerals will only apply to similar substances. One way this might work, if you had a mineral severance for iron, coal, and minerals, the court might say, well, iron and coal are both solids, and so the catch-all term minerals will only apply to other solids. Or if you had oil, gas, and minerals, a court may say, well, oil and gas are both liquid hydrocarbons, and so, or at least they're hydrocarbons, so the term minerals in an oil, gas, and mineral lease will only be, the minerals will only apply to other hydrocarbons or other liquids or fluids. So that's another test you'll see. It's fairly common for courts to look at, was the substance known to be valuable at the time? If it was not known to be valuable at the time, then the courts may say the catch-all term minerals is not going to include it. If the granting clause mentions a specific type of operation, like the granting clause is talking about mining rights, the courts may sometimes will say, well, because the granting clause talked about mining rights, but maybe it didn't mention drilling, this is going to really only the catch-all term minerals will apply to things that you produce by traditional mining. And then finally, one of the things that in some jurisdictions will be relevant is whether the production process would destroy the surface. So if you would need to strip mine and really destroy the entire surface in order to produce, say, clay or some other substance that's in dispute, some courts will say the parties would not intend for there to be a surface destruction type of mineral production unless they specifically listed that substance. Otherwise, some landowner who grants a mineral lease is not anticipating that his entire surface will be destroyed by strip mining. And so this is something you look at. For examples, Texas, the leading case is the Moser case. Here there was a reservation of oil, gas, and other minerals. The parties disputed who had the right to uranium ore, and the court reviewed the existing principles and then modified those rules for prospective transfers. So the Moser new rule applies to later severances. And this is an interesting example because between the old rule and the new rule, you see, and the fact that they distinguish and made it prospective only, it really picks up a lot of the things that different courts consider. But here they said that at least going forward for future severances, the test is what's the ordinary and natural meaning of the word minerals, and if the ordinary meaning would include the substance in dispute, then that substance that's not specifically named in the severance, but the severance does refer to minerals, then that disputed substance will be a mineral for purpose of the mineral severance if you ordinarily would think of that substance as a mineral. Limitations on this, again, this applied to post-Moser severances. And the prior rule, you'd begin by looking at, would you ordinarily think of the thing as a mineral? If the answer was no, then it's not a mineral. But then after that, if it was something you would normally think of as a mineral, it still would not be, the disputed substance still would not qualify as a mineral for purposes of the severance if the methods of production might destroy the surface. So that's another limitation, that this old rule had, included the surface destruction part of the test. And then finally, there are a few substances, not lithium, but a few substances that the Texas Supreme Court listed out where, as a matter of law, it's already established whether the substance is a mineral or not. And so the test basically now in Texas is, first you'd ask, would you normally think of this thing as a mineral, whatever substance is at issue? If no, then it's not a mineral for purposes of the severance. If yes, you say, is this conveyance after the date set in the Moser case, June 8th, 1983? If yes, then you're done. If it's a post-Moser severance and you would normally think of the substance at issue as a mineral, it's a mineral for purposes of the severance. If it's an older severance, then you have to go to the old test, where that top question, would you think of it as a mineral, is the first part of the old test. And then the second part of the old test is, would all the methods of production avoid substantial harm to the surface? If none of the methods of production would destroy the surface, then then the answer to this question is yes. All the methods would avoid substantial harm, then it's a mineral. But if some methods of production, even if it's not the method of production that the mineral lessee wants to use, but if some methods of production of that particular substance would harm the surface, cause substantial harm, then it's not a mineral if that substance was not explicitly listed. Trying to speed up here a little bit. As an example of a state that applies a little different rule, the Louisiana Supreme Court has not set out a specific test. It's really looked at a number of factors. So if you think about an old case where the severance was or the reservation was of iron, coal, and other minerals, the court said that does not include oil. And the court's reasoning relied on multiple considerations. One, they said that justum generis doctrine. They said, well, iron and coal are both solids. Oil's not a solid. That would suggest the general term minerals doesn't include oil. The granting clause talked about mining rights, but it didn't talk about drilling. So the court said, no, that's another thing that suggests oil would not qualify as a mineral. And furthermore, as of 1888, you did not yet have oil and gas production in the state. They said, therefore, this is not going to qualify as a mineral. I would note again that 2024 legislation that says the substances in the water, produced water, are going to belong to the oil and gas operators. Arkansas is an example. It's important both because that's where a lot of people are talking about producing lithium, but also it illustrates a different test. Here, the Arkansas court seemed to pretty much just apply, was this substance commercially recoverable at the time of the severance? That doesn't list that substance specifically, but uses the catch-all term minerals. And if something was commercially valuable at the time of the severance, then the catch-all term minerals is probably going to include it. And that's the Strohacker test. And here, curiously, some of the courts have analyzed this as whether brine is a mineral. So they were talking about as if whether or not brine is a mineral. They weren't even thinking about, what are you going to extract from the brine, but is brine a mineral? And they suggested that it would depend on when the severance occurred, that if it was occurred before a certain, the beginning of 1955, you did not yet have brine production. After that date, people had begun extracting bromine from brine. And so if it's a later than January of 1955 severance, then brine would fit under the catch-all of minerals. Query, if you're not trying to extract bromine from the brine, do you still look to the same date because brine itself was valuable or known to be commercially valuable as of the start of 1955? Or do you apply a later test if now you're talking about extracting from brine, but you're talking about extracting a different substance. So just a query there about whether the 1955 date is still the relevant date if you're talking about lithium extracting from brine instead of bromine. Pennsylvania is interesting because they also they look at what, a couple of things. First, the first part of the test in Pennsylvania is going to be what's the common understanding of minerals. And in doing that, one of the things that they're going to say, what was the common understanding of minerals? And it's going to be at the time of the severance. But the interesting thing I noted is they said that at some point, once you have established cases saying that a particular substance is or is not a mineral, then that can become a settled rule of property law, even if the understanding of what's a mineral changes. And so, for example, in 1836, the Pennsylvania Supreme Court said, because chrome is understood to be a mineral, or because the common understanding of mineral is something metallic and chrome is a metal, minerals would include chrome. And on the other hand, oil was not a metal, so they said oil is not a mineral in 1882. And then more recently, the court said, even if the common understanding has changed, maybe nowadays people would think of oil as a mineral, but it's now an established rule of property law that oil is not a mineral. And so we're going to stick to that, even if the people now would think of oil as a mineral. I suggest that there's probably not a current, there are no decisions establishing a rule of property law about whether lithium is a mineral, and so you probably go to the common understanding. I'll just pass through the West Virginia, Ohio. Ohio is kind of like Louisiana. You look at a number of factors, in Kentucky, and because we're starting to run low on time, I want to go to what are a few other issues. And one is authority for pooling or unitization available? That could be an issue because remember, if you're thinking about pumping brine, for example, as opposed to produced water, a question would be, if you're going to do something that looks like secondary recovery with some production wells and some injection wells, do you have pooling authority? And if your lease contains pooling authority, is that only for oil or gas, or would it be for other substances? What about unitization authority for field-wide units? That's could also be an issue. And even for brine, or excuse me, even for produced water, what if you've got an oil or gas unit? Does that drilling unit and the pooling for oil and gas, does that apply to any brine that's, or excuse me, any produced water? So you've got a pooling for oil or gas, and let's say there's the oil or gas from that pooled unit also contains produced water. Does the pooling rule also apply to the brine itself? Or would you go back to where's the well located? A couple of states like Arkansas, Oklahoma, Louisiana authorize pooling or unitization for brine. And finally, before seeing if there are any questions, I would note that if you have production of lithium, there's going to be an issue, particularly if it's an existing, say, oil, gas, and mineral lease, and not a lease that specifically addresses lithium. There's going to be an issue: is a royalty due? And if so, how do you calculate it? And if you think, for example, do you use the value at the well of the unprocessed brine, or do you use the value of the processed lithium? And as far as things I've heard about the extraction process, and then the processing to get the lithium oxide that actually goes into batteries. If you look at the market value of that lithium oxide that goes into the batteries, that's, I suspect, going to be much more than the value of the unprocessed brine. So if post-production cost and fights about those are an issue in oil and gas, particularly with natural gas, think about on steroids, if now there's a basis to fight about whether you can deduct post-production cost from the value of the lithium or the brine. So with that, I will try to pause and see if there are any questions. If not, I can maybe make a few comments, but let me see. Looks like there is at least one Q&A. Okay, there's a question. If an oil and gas lease refers to oil, gas, and other minerals, which would be fairly common, but all the other references in the lease strictly deal with oil and gas, can one argue that the lease was only intended to cover oil and gas? I think so. I mean, some of the oil, certainly some of the oil, gas, and mineral leases that I see have a catch-all royalty for other substances. But if there's nothing that really addresses any other substance, well, if it says other minerals, that must mean something. But yeah, that's interesting. There are cases that, for example, that say, because the granting clause talked about mining rights, but didn't talk about drilling rights, it's only going to cover mining. And so to the extent you have other things in the lease that are addressed specifically oil and gas, but not other substances, I see that you could use that to argue that lithium is not covered by other minerals. But the other minerals, I think the question would be, is there a way to say that at least some of those other provisions, other than the habendum clause or the granting clause, could cover oil, gas, and at least a few other things? Because otherwise, if you say, well, the other provisions of the lease only relate to oil or gas, then would that mean that other minerals has no meaning? I guess that would be my concern about saying that, are the potential counterattack to saying that the other minerals did not pick up lithium because most of the other provisions of the lease only refer to oil or gas. Let's see. There are a few things in the chat. Okay, I think those are more, I guess, housekeeping things. So I think there's only the one question, which I kind of gave an answer to. I don't think there's a certain answer, but I gave my thoughts. Certainly, I'm happy to talk to folks to answer questions outside the webinar, and you have my contact information. In fact, I'd be delighted to hear what some of you are actually seeing and thinking about. And that will help me in future presentations.